Sheriff John Feyen is being sued in his individual capacity and also in his official capacity as the Assistant Chief of Police at Fort Collins Police Services. It was while John Feyen was campaigning for the office of sheriff that he so maliciously defamed me. So he's being sued specifically for defamation per se, actual malice. The actual malice piece of this lawsuit is required because John Feyen is a public official, and so I have to prove that John Feyen knew when he was defaming me that he was lying. That's easy to do because he's testified under oath about the very things he lied about. And ironically, much of the evidence of his actual malice is included in the secret file that he intentionally hid for 8 years. Now, that file was hidden for 8 years so that Larimer County could ensure that the statute of limitations had all expired before I got access to the records. Larimer County Attorney David Arode actually put that in an email where he wanted the key evidence to be kept for 6 months past the statute of limitations. However, the sheriff's office, Sheriff Justin Smith and John Feyen, amongst others, actually pulled the GPS tracking device records from all case files and hid it in a secret file. So John Feyen is being sued in his individual capacity and his official capacity, and he has a pile of attorneys trying to defend him. When the lawsuit was filed against John Feyen, Lindsay Riley and David Vandenberg entered their appearances on behalf of John Feyen. That means that John Feyen hired 2 of his friends to represent him. It was obvious in John Feyen's choice of attorneys initially that John Feyen thought the courts were going to rule in his favor and that he didn't need to take this lawsuit seriously. So Lindsay Riley and David Vandenberg made an error at the beginning of this case when they filed an anti-SLAPP motion. And what an anti-SLAPP motion is in defamation cases is oftentimes defendants will file basically a counterclaim in the form of an anti-SLAPP motion saying that the defendant had a right to defame the plaintiff. It's a loophole. It does have its purposes, but anyway. So Lindsay Riley and David Vandenberg filed this anti-SLAPP motion, and in Colorado the law states that if you file an anti-SLAPP motion, an evidentiary hearing is required to be held. This is how seriously the law takes defamation cases. So we have an evidentiary hearing, which is kind of comical at this stage because Vandenberg and Riley did not even understand that the law required an evidentiary hearing, and I think if they would have known that before they filed the anti-SLAPP motion, they never would have filed the anti-SLAPP motion, because what that means is that John Feyen was forced to get on the witness stand in this defamation per se actual malice case against him. And if any of you know John Feyen personally, you know that he is not very good at speaking in public. He's not good at thinking on his feet. Even when he has a script to follow, you can tell he's struggling to speak clearly and to make his point. So cheers to Vandenberg and Riley for filing an anti-SLAPP motion, not knowing that John Feyen was going to be required to be on the witness stand under oath. Not that under oath means much to John Feyen, but at least we have a record, a transcript of that public hearing. So we have the anti-SLAPP evidentiary hearing. Judge Joseph Findley rules against John Feyen. He rules in my favor. And at that point, a whole bunch of powerful insurance attorneys enter the picture because they realized that John Feyen was liable for his defamation per se actual malice. The evidence is undeniable. John Feyen's own admissions during the evidentiary hearing propelled Judge Findley to follow the law and rule in my favor and rule against John Feyen. So the insurance attorneys are a whole different breed. Vandenberg and Riley look like basically like Mayberry RFD attorneys compared to Michael Milstein and his firm. Michael Milstein is the attorney who handled much of John Feyen's case until he was removed. Michael Milstein is equivalent to Brian Reynolds. Brian Reynolds is Justin Smith's defense attorney, Sheriff Justin Smith's defense attorney, and Brian Reynolds is currently under investigation by the Colorado Supreme Court Office of Attorney Regulation Counsel because in the Smith case, Judge Stephen Jouard issued an order on my motion for sanctions ordering the Colorado Supreme Court Office of Attorney Regulation Counsel to investigate Justin Smith's attorney, Brian Reynolds. Michael Milstein has done extraordinarily unethical things to me during this lawsuit against John Feyen. During John Feyen's deposition, Michael Milstein constantly coughed, choked, sniffed, made all kinds of bodily noises as signals and clues for how John Feyen was supposed to answer or not answer. Numerous times, Michael Milstein actually hit John Feyen in the arm to tell John Feyen to stop talking. Michael Milstein did that because every time he hit John Feyen, he realized that John Feyen was about to put on the record additional evidence of actual malice. In the Justin Smith case, Smith's defense attorney, Brian Reynolds, is not alone in this decision-making process because Justin Smith has included the county, Larimer County, in his liability. So David A. Rode and Frank Hogg are also involved in Justin Smith's case. It's interesting because David A. Rode was a defendant in the federal lawsuit against Smith and Feyen because David A. Rode assisted Smith and Feyen in concealing the records of the illegally attached GPS tracking device. So David A. Rode, in a direct conflict of interest, was initially trying to represent himself, A. Rode, and the county and Smith. And when I brought that to the attention of the judge, that this is all conflicts of interest and completely improper, as we move through depositions and deeper into this case, then another attorney, Frank Hogg for Larimer County, entered his appearance on behalf of David Arode. So we have a lot of players in both of these cases. And when I say players, I mean players, because what's at stake here is taxpayer money and insurance money. John Feyen's attorney, Michael Milstein, also scheduled depositions when he knew that I could not attend. These were out-of-state depositions. The people that he was deposing out of state were, first was a child victim that he threatened to depose, and the second was a known domestic violence abuser. So Michael Milstein refused to schedule that during a time when I could attend, which was obviously the plaintiff's right to attend. And because I could not attend, then Michael Milstein had free rein with this domestic violence abuser. And when I say Michael Milstein had free rein with a domestic violence abuser, what I mean is that because the domestic violence abuser proudly basically has nothing more than an elementary level education, Michael Milstein had to read the domestic violence abuser's answers for him, and he allowed the domestic violence abuser to speak for nearly 30 minutes on a basically a rant and a rage-filled, psychotic 30 minutes full of lies. After Michael Milstein was removed from the John Feyen case, other attorneys from Milstein's law firm took over, and that's when it got even more insane as far as these attorneys engaging in unethical and illegal procedures. Other attorneys in Michael Milstein's law firm took control of this case, and when they did, for some reason they thought they were going to get away with lying to the Colorado Court of Appeals. Even as I talk about it now, it is mind-boggling, unbelievable. The only reason I know exactly what Milstein's law firm did was that one of Milstein's attorneys accidentally sent me an internal email, meaning that I got an email between the attorneys at Milstein's firm as they were discussing how to deceive the Court of Appeals and basically how to fabricate an email to further deceive the Court of Appeals. This all had to do with the fact that, well, Milstein's law firm admitted that they didn't serve me a motion. Milstein's law firm admitted to the Court of Appeals that they didn't serve me a motion. And then when they got caught not serving me the motion, they did something even worse. Again, I learned about this because somebody from Milstein's law firm sent me an email where they were praising this person they called the rock star. I don't exactly know who the rock star is, but this rock star appears to have fabricated an email to make it look like they did send me the motion, but they didn't. And whoever the rock star is forgot one key aspect on this fabricated email that means that I can prove it was fabricated. They know I was never served the motion. They know they never even emailed me information about the motion. So that's where we're at with the whole John Feyen insurance attorneys' just insane, unethical, and illegal actions. But the good news is when the Court of Appeals discovered that Milstein and his attorneys and John Feyen, and they were all participating in this illegal deception against the Court of Appeals. The Court of Appeals ruled against them, and we are fully moving forward in the John Feyen case. We need to talk a little bit more about Lindsay Riley and David Vandenberg, because during John Feyen's deposition, well, actually after John Feyen's anti-SLAPP evidentiary hearing where he testified under oath and the insurance attorneys came on board, Riley and Vandenberg were not allowed to basically talk anymore or file anything whatsoever. And again, at this point it's comical. They had no idea what they were doing. However, when John Feyen testified during his deposition, he testified under oath. He swore that Lindsay Riley and David Vandenberg were no longer his attorneys. That means that he said that they were no longer his attorneys because he had fulfilled the contract, they had been paid, and he wasn't paying them anymore. And that means that they should have withdrawn from the case. However, they didn't withdraw from the case because if they remained as attorney of record for John Feyen, they got access to information that was protected. Again, totally unethical. But at this point, who cares about ethics when their own client blatantly breaks the law? Why would his attorneys be any different?